This is the 2010 or the 2013 official text, but the sponsors, and when I say the sponsors, it is the two law reform organizations that have collaborated to create the UCC, that is the Uniform Law Commission and the American Law Institute, have never kept an official text. When an article is revised, and I mentioned that in 1972 there was the first major revision of Article 9 that went out to the states, and so in the records of the two organizations, that's the latest version of Article 9. When we revised it, well, I wasn't with the organization then, but when it was revised then, that had a rippling impact through a lot of other articles. For example, there are cross-references. Article 3 may have a cross-reference to something in Article 9, and that cross-reference may have become incorrect because Article 9 was redrafted. Well, we try to catch all those. If Article 9 is revised, there will be a set of trailing amendments to other articles, like state, when you adopt Article 9, you need to also amend Section 2, whatever it is, to change the cross-reference. We caught most of those, but not all of those in the text, but we by no means caught all of those in the comments. The publishers have caught a bunch of those. We are in the process. I mentioned the Permanent Editorial Board for the Uniform Commercial Code, which kind of is a joint enterprise of the two organizations that oversees the development of the code, determines when studies should be undertaken to see whether the code should be updated, and has other functions that I'll talk about later in the semester. But the Permanent Editorial Board has undertaken a project to create an official text which will be owned by the two organizations for the first time. And we've gone back to source documents and all kinds of internal correspondence. And I spent a lovely week a year ago reading every line of Article 2 word by word and comparing it with other articles until I was practically blind. And then turned it over to somebody else to do the same thing, and they caught a half dozen things I didn't catch, and we turned it over to a third person who caught another half dozen things. So there will be an official text. You don't need to know this. I just want to give you a sense of how the UCC is created and how it develops, and it's been in some senses extraordinarily thoughtful and intellectual, and in some senses kind of slapdash and haphazard. So there you have it. I also mentioned, and I got questions from two people along these lines. I did mention that there are in a world in which we are a continental nation with a federal system, so states have sovereignty and a role to play, but we have a rather powerful and far-reaching central government as well. It's hard to figure out what legislation ought to be at the state level and what legislation ought to be at the federal level. But there's a history here. For example, at the federal level, there is no institutional expertise in contracts, commercial law, family law, things such as trusts, wills, estates, things of that nature. That has developed at the state level, and because the federal government tends to act in broad sweeping legislation and then leave the details often to agencies to flesh out, it's probably best that in those areas where there is no pressing need for federal legislation and no history of expertise at the federal level, it's probably best for those areas of law to remain as close to the people as possible, and that's through state action. It's also the case that if what you want is national uniformity, you get it at the stroke of a pen at the federal level, right? Because of the supremacy clause of the Constitution. So the federal government could, the Congress could adopt a version of the Uniform Commercial Code, send it to the President to sign. That would then preempt all of the states, and it would create uniformity. There are a number of problems with doing that. Among them is the fact that even though it's important that states' laws line up, that is, at a core essentially be the same in the commercial law area. I gave you the example of the money market center lender who's lending in all the states around the United States, and how a confusion of laws just creates transaction costs as they have to research and do detailed research. Nevertheless, states have important interests that differ from other states. And if you adopt something like the Uniform Commercial Code on a state-by-state basis, even though you have a central set of core concepts that are the same from state to state, nevertheless, each state can express its individuality by, as it adopts a Uniform Act, changing it in some respect. You'll find that in Article 9, with regard to some of the core concepts, like the choice of law, conflict of laws principles, no states have made any changes because it would just be horrendous if they did. I mean, don't worry thinking about the context. I'm just saying the states have understood they shouldn't monkey with that. But, for example, I don't know how many of you, like me, plan to win the lottery tonight. But if you were to win the lottery, then you would be entitled to, and you didn't take the cash option, then you'd be entitled to a stream of income from the Lottery Commission or whoever pays it out. I don't know who the authority is on that. But you'd be entitled to a stream of income, either monthly or annual payments over a period of time. And those would be, in Article 9 parlance, accounts. Again, please don't worry about any of this stuff. I'm just telling a story right now, okay? Those would be accounts, and Article 9 would then have some rules about what the state must do in paying that money out, which the states might not like. And so you'll find that in quite a number of states, those particular provisions were changed so that state lottery winnings were subjected to some of the rules but exempted from some of the other rules. Well, that's an example of a state reflecting a local concern, considering a value to be a higher value than we valued it in drafting the UCC. And one of the advantages to doing things on a state-by-state basis, even though it's slow and cumbersome, is that it allows for play in the joints, if you will. It also makes it easier for change to occur. It's very hard to get the federal legislature's attention. So if amendments are necessary, it's going to be very difficult to amend. On the other hand, while it's not easy to amend at the state level, what you'll see sometimes is there's an example from early Article 9, where early Article 9 created a 10-day grace period to do something. It doesn't matter what it is. That proved to be impractical. And rather than going back and redrafting the UCC and then sending it back out to the states just began changing on their own the 10 days to 20 days. So that by the time a few years had gone by, virtually every state on its own with very small bullet point legislation changed 10 to 20. And then some years later, we got around to revising all of Article 9, and we just went along with it and put in 20. So it's true that at the federal level, you can get one size fits all, you can get national uniformity, you can get it quickly, and depending on how quickly Congress acts. But you can do it in the stroke of the president's pen signing federal legislation. There are downsides to doing that. So the idea of the Uniform Law Commission has been to select areas where not uniformity necessarily, because uniform is a little misleading, but where it makes sense for the states to line up to be essentially the same. And so you find that there's a Uniform Trust Act. There are uniform acts governing the formation of partnerships, limited liability companies. If heaven forbid something happens to one of us on the way home tonight, and we're in a car accident and killed, and our body is taken to a hospital, the hospital will be able to harvest organs if you sign the organ donor line on your driver's license, and the hospital will not worry about liability. They won't have liability will say you didn't have permission to do that because they are authorized to do that under the Uniform Anatomical Gift Act, which was first drafted in the 1960s, revised a few years ago. It was in effect, I think, in every state. So there are a broad range of areas where uniformity of law through the state law process, I think, makes a lot of sense. And then there are areas, I mean, if you're talking about environmental laws, I don't see how a state, at some level, a state can impose its own environmental laws. But presumably most environmental laws need to be at a national standard or national level, and they tend to occur at the national level. So again, that's just kind of playing around with this a little bit to give you all some insights. I'll be happy to take questions. If not, open to Article 1. And let's take a little tour. Okay. I want to focus on a few things that will be important during the semester. Article 1 is a part of every other article. Article 1, Section 101. This article may be cited. By the way, do you see in 1101A where it says this act and the act is in brackets? The states, if you see this in the states, you won't see those brackets, but it may not, the word act may not be used in a given state. For example, in some states it would be this chapter, and it would be a chapter of the state statutes that would include all of the Uniform Commercial Code. They're part of Chapter 37 or something like that. So we put that word in brackets and we tell the states, pick the word that fits the way you compile your statutes. So this act may be cited as the Uniform Commercial Code. This article may be cited as Uniform Commercial Code General Provisions. And then 1102, it's very helpful if legislation defines internally what it applies to. Otherwise, you're left guessing. This article applies to a transaction to the extent that it is governed by another article of the Uniform Commercial Code. Okay? So the Article 1 is part of and applies to every other article, but it doesn't have its own subject matter. It doesn't have a set of transaction types that are specific to Article 1. So what are some of the general principles? Well, Article 9 answers, as I indicated last class period, answers an awful lot of questions. But it doesn't answer every question. And so if you have a problem that arises under Article 9, and Article 9 doesn't give you an answer, where do you look? And if you take a look at 1103B, unless displaced by the particular provisions of the Uniform Commercial Code or whatever the state calls their version of it, the principles of law and equity, and then you can skip the including stuff. I wish we had left it out in drafting because it's only examples. The principles of law and equity supplement its provisions. I've gone all the way to the end of it. So where do you go? You go out to general common law and equitable principles. And I think of Section 1103 using Star Trek terminology as a wormhole to the common law and equity. Okay? The Uniform Commercial Code floats in a common law sea. And many of the answers are found outside in the common law. Section 1201, I indicated to you that it is a set of definitions applicable to more than one article. Some that we might look at in this course. You know, Article 9 deals with security interests created by contract. And the contract is called a security agreement in Article 9. And I'll never ask you to look at it. I assume you learned this in contracts. I won't ask you what agreement means from a contract standpoint. But a security agreement is a type of agreement. An agreement is defined in Article 1. If you cared to look, I just point that one out in passing. We will talk in Article 9 about good faith. And Article 9 contains its own definition, but its own definition is the same really as the Article 1 definition, so we might as well look at it here. The reason Article 9 contains its own definition and Article 1 also contains a different definition is timing. Revised, Article 1 was revised in 2003 or 4. Article 9 was revised in 1998 or 99. The Article 9 had a definitional change to good faith, different than the original UCC from 40 and 50 years ago. So that was stuck in Article 9. And then that was picked up in Article 1 when Article 1 was revised. So sometimes you see the same thing defined in two articles. By the way, if you this won't happen. I can't think of an instance involving Article 9, but I can think of instances involving other articles. If you see the same term defined in Article 1 and defined in a different article, and they're defined in different ways, then for a transaction within that other article, you use the definition that's in that article, not the Article 1 definition. Okay. So, good faith means honesty in fact. That means you are acting subjectively honestly. You're not trying to cheat, lie, steal, or engage in other nefarious conduct. And who would decide whether you did have that evil state of mind? A fact finder, based on evidence at trial. And the observance of reasonable commercial standards of fair dealing. That's an objective test. Are you acting fairly? Not are you acting competently. It's not the same as negligence. Okay? Are you acting fairly? And I'm not going to do much with good faith because I assume you studied it in first-year contracts, but it will come up from time to time, and here and there I'll say a word about it. Okay? I'm on a roll. I'll stop anytime you want for any question you want to ask me. Okay? If you look, continuing down the alphabet, I'm going to do this in reverse order. Definition 27 is person. Article 9 will often use the word person, and person means an individual, so a flesh and blood human being, or an entity, like a corporation, LLC, etc., that has its own existence, separate and apart, that can own property, that can sue and be sued in its own name, etc., etc., etc. Sometimes you'll see a statute refer to individual rather than person, and then that statute applies only to flesh and blood folks. Sometimes you'll see a statute refer to the word organization. And if you go up to 25, you'll see organization means a person other than an individual. So person includes flesh and blood individuals and entities. Individual is just flesh and blood. Organization means entities. All right. So it's not a big deal, but I pointed out in passing. Definition 30 is sort of the least helpful definition I've ever seen. Purchase means a person that takes by, purchaser means a person that takes by purchase. Okay, that's helpful. But purchase is the key word there, okay? And we're going to talk you saw in the material for tonight the use of the word purchaser. But here's a concept that I want you to have from the outset. The UCC, and particularly Article 9, is big on what I think of as nesting definitions. That is, let's look at the definition of the word purchaser. If I'm a buyer of goods, am I a purchaser? Several of you are nodding yes, and that's the end. Purchase means taking by sale. Well, okay, that's as far as I needed to go, right? I'm a purchaser. If I am a lessee, if I lease goods, am I a purchaser? Well, your English language usage would say, right? But purchase means taking by sale, lease, so the answer is yes, I'm a purchaser. If you need to borrow money from me, and I loan you the money, and you give me as collateral a security interest in your car, an Article 9 security interest. So I have a security interest created by contract between you and me. I'm a secured party, right? Am I a purchaser? Yeah. Purchase means taking by sale, lease, discount, negotiation, security interest. If I am a donee, if you give me a gift, am I a purchaser? Yeah. Isn't that amazing? Taking by sale, lease, discount, gift. There it is. Okay. Now, what do all those things have in common? What's the commonality there?
They're involved in a conveyance of...
There is a transfer of an interest in property. The purchaser is the person that receives the interest in property. It can be a limited interest, like the interest of a lessee is entitled to the asset, isn't ownership. It's the right to possess and use the asset for the term of the lease, right? But if you all have been introduced to property as a bundle of sticks, right, bundle of different rights. So a purchaser is somebody who takes one or more of those sticks in a voluntary transaction. Okay, so you see at the end the language, or any other voluntary transaction creating an interest in property. When you see a phrase like that, sort of a general phrase at the end of a laundry list, the language in the general phrase goes back and modifies everything else in the list. So if I have a security interest in your car and you don't pay me back and gone into default and I repossess your car and I hold an Article 9 foreclosure sale, disposition sale, at which your interest in the car is going to be divested from you and is going to be vested in somebody who's going to buy the car at the sale. Is the buyer at that sale a purchaser? The answer is no. Why is the answer no? It's not a voluntary transaction. It's a forced transaction. I'm selling your car to somebody else. It's not voluntary on your part. You're not voluntarily turning over your ownership. I'm using a legal process to divest you of that ownership. Okay. Now, when I talked about nesting definitions, if the UCC means any or all of these people, it will use the word purchaser. Anybody who takes any property interest in a voluntary transaction. If it only means to talk about secured parties and not other purchasers, it will use secured party. If it only means to talk about buyers and not any other purchaser, it will use buyer. If it only means to talk about lessees and no other purchaser, it will use lessee. Okay? So I've got an overarching term which can apply to any and all, and then I've got subset terms that apply to specific subsets. And we're going to see that a lot. For example, I said last time that the easiest type of collateral in Article 9 to understand is goods. We can have security interest in intangible stuff, and we'll talk about it some, but it's easiest to understand a security interest in goods because goods are so intuitive, right? But when we get to Article 9, you will see that there are 4 subsets of goods. You don't have to write this down. We're going to get to it. There's inventory, farm products, consumer goods, and equipment. And we have some different rules depending on which of those subsets we're in. If we're in consumer goods, for example, there's some consumer protection rules built in. If there's inventory, we have some rules built in that make sense in the context of businesses that sell inventory. But goods is the overarching term. So if the term goods is used, it means all of them. If one of the other terms is used, it means only that subset. So get used to the nesting definitions. I want the security agreement on the next page, security interest on number 35. It may not be in the next page in your version. Security interest. For now, we'll leave it at the first sentence. Later on in the semester, we'll have to push a little bit beyond that. Security interest means an interest, and when they say interest, they mean a property interest. It is a limited property interest. In personal property, and I'm not going to mention fixtures again, right? I'm just going to read past that when we get there. Security interest means an interest in personal property which secures payment or performance of an obligation. So there is an obligation and there is collateral for the obligation. And the main point of the definition right now is just to focus you on the fact that it is a type of limited property interest. And then two terms that I want to mention, and the code is extremely difficult in this regard. Take a look at the word writing, okay? Would an email be a writing under that definition? Just read it. Would a Word document? Would a PDF? Just under the definition. Somebody take a shot at it.
Probably not, simply because they're not traditionally considered tangible, but it would definitely depend on how you define the tangible.
Yeah, but you focused on the right word. Printing, typewriting, or other intentional reduction to tangible, meaning physical. Okay? So when the Uniform Commercial Code was first drafted, of course, in the 1940s and the 1950s, the computer revolution was far in the future. And Article 1 has been revised, but in some places within the Uniform Commercial Code, it's still important. For example, in Article 3, which those of you who took payment systems, Article 3 deals with checks, promissory notes, and things like that. And the UCC doesn't cover electronic versions of those things. So the word writing is the correct word. So we use writing. Sign. Sometimes we talk about signed writing. Look at signed.
Just to confirm, so a PDF or an electronic representation wouldn't count as a writing?
It's not a writing.
It's not a writing, okay.
Not writing. Okay. Signed. Does signed include an electronic signature? As defined there? I'm sorry?
I would think so.
Okay, why? What language within there picks up electronic signatures?
I didn't catch that writing part. Since it refers to writing.
Writing. The word writing is embedded, right. And one of the things I want to do is we're gonna work this semester on reading really, really closely and carefully these statutes. So this version of signed would not pick up an electronic signature. Question?
You printed out an email?
I'm sorry?
You printed, I'm not trying to be picky here, but I'm just asking.
Well, if you print out an email, it's now a writing, and if you manually sign it, it's now a signed writing. Okay. Now, how many of you in first year contracts studied well, you would have studied both, the Uniform Electronic Transactions Act and the Federal Digital Signatures in Global and National Commerce Act, or commonly referred to by everybody as e-sign. Have you ever heard those terms?
Might have skipped it.
Well, you have to know about those things. Okay? But all you have to know for this course, I can tell you, and you won't have to worry about it. Okay? The Uniform Electronic Transactions Act has been adopted in 47 states, including Texas. Basically, what it says, and there are exceptions, it doesn't apply, for example, to court records. It doesn't apply to wills, for example. But it certainly applies to anything in the commercial world and beyond, but our current focus is just the commercial world. And what it says is, if a statute requires that something be in writing, that requirement can be satisfied by an electronic document. Okay? In other words, it overrides the UCC limitation of writing. And it goes on and it says, and if a statute requires that something be signed, the signature requirement can be satisfied by an electronic signature. So in other words, the UCC says writing is limited to the tangible world, and signed is limited to the tangible world. But when you pile the Uniform Electronic Transactions Act on top of it, what they say is if the UCC require, or another commercial statute, requires something to be in a tangible writing, in fact, it's to be interpreted as including emails, PDFs, Word documents. And if it says something has to be signed, it's interpreted to mean an electronic signature. Now I'll tell you an interesting story. The Uniform Electronic Transactions Act was kicking along very, very nicely in a number of states, and had been adopted in 20 or so states, and it got to California. And a set of consumer groups wanted to make absolutely certain that their wish list was fulfilled. And in the California legislature, they found a legislative body that was willing to give them their wish list. And so all kinds of additional limitations, font size, format size, things like that, were put into the California version of the Uniform Electronic Transactions Act, so that you could do electronic transactions in a whole lot of states one way, but in California you had to do another way. Well, as you can imagine, that created some consternation in the business community, so they went to Congress. And Congress passed in 2000 or 2001, I guess it had to be in 2000 because Clinton signed it. So they passed a piece of federal legislation which does the same thing as the Uniform Electronic Transactions Act, without all the California add-ons. Okay? But what the act says is that it is preempted. The federal act itself, e-sign, says it is preempted in any state that has adopted the Uniform Electronic Transactions Act as drafted by the Uniform Law Commission. So that if you're in a state that adopted pure UITA, then federal law steps back. It's thought of as a step back provision. Okay? Federal law doesn't apply. State Uniform Electronic Transactions Act applies. If you're in California, though, its version is overridden by preemptive federal legislation, and if you're in one of the 3 or 4 states that hasn't adopted UITA, then that applies. What do you need to know? You need to know that for our purposes in anything that we deal with, if something says writing, it doesn't really mean it. Now, when we got around to revising Article 9, there needed to be a term that would pick up both writings and electronic communications. Because we didn't, in drafting Article 9, we didn't want to rely on the UCC as overlaid by some other statute. We wanted to incorporate medium-neutral terms right into the UCC, so you didn't have to go outside it. So we wanted a term that would pick up both writings and electronic communications, an email, a Word document, a PDF, whatever information can be stored electronically in some way so that it can be retrieved. We don't need anything to cover Snapchat. Doesn't Snapchat just disappear? I've never used it. You write the words and then it disappears. But any electronic communication that can be retrieved and used again or reviewed again. Does anybody know what that term is? Well, later on, when Article 1 was amended, that term was imported into Article 1. So you'll find it in Article 1 and in Article 9. And the term is record. So back up and look at the word record, which is in both 1 and 9. Record means information that is inscribed on a tangible medium. That's the physical world. That's a writing, right? Information inscribed on a tangible medium, that's a writing. Or that is stored in an electronic or other medium and is retrievable in proceedable form. And so I don't usually use the word writing, sometimes, but I usually use record. And when you're just getting used to it, it's sort of head-wrenching. What are you talking about, record? But a record, as I use that term, will mean either a physical or an electronic document. Okay. So Article 1 needs to have both. Because, again, these definitions apply to a bunch of other articles. And Article 3 can't use record. Article 3 needs writing. But those are all the definitions that I want you to see in Article 1. For purposes of Article 9, don't worry about writing and signed. I was trying to tell you a story and trying to explain to you why we use record in Article 9. I think writing is used in one place in Article 9 in which certain information has to be provided to a consumer in a post-default situation, and I don't even remember if I teach it or not. I might. We'll come to it later if we come to it. Any questions on what I just did? Okay, let's keep playing around with Article 1. Look at 1202. Sometimes in Article 9 it will talk about people having notice of things, and sometimes in Article 9 it will talk about people having knowledge of things. And notice and knowledge are not defined in Article 9. You will find them in 1202. So if you want to know what knowledge means when you're reading a statute, come back here. The reason notice and knowledge are not listed in the list of definitions, because 1202 is largely definitional, but there are a couple of substantive rules in here, and we try not to put anything in the list of definitions if it's more than a definition and contains a substantive rule. So 1202. 1204. The term value. Just in today's assignment, remember we talked about value? Person with voidable title has power to transfer a good title to a good faith purchaser for value. Value is used in many, many, many other articles, Article 2, Article 9, and it's defined back here in Article 1. Okay? So that's 1204. And I think those are the only ones that we need to look at now. From time to time, there may be a minor provision of Article 1 that we glance back at. But that's what I want you to get for today. Any questions yet? So let's go to Article. Yeah, there was a question.
More of a curiosity. In the definition of record, it talks about the electronic medium, but there's no definition for an electronic medium.
It says electronic or other medium, and we were that definition actually comes straight out of the Uniform Electronic Transactions Act, and was then adopted directly from that act into the federal e-sign legislation, and we then plugged it into various places in the Uniform Commercial Code. And we did not define electronic medium, and we didn't limit it to electronic medium. I mean, people are talking now about biological computers and storing information in cells, and we didn't want to limit. We didn't want to limit this to a certain type of technology, circa 20 whatever when we drafted the thing. So no, there's no definition of electronic or other medium, and there's a quirk to it also. It says retrievable in perceivable form. And it's nobody's ever litigated, nobody ever will, but it means you can pull it back up and understand it. And to me, being able to understand it is different than being able to perceive it, right? Because you could perceive something, but it could be gobbledygook. Nevertheless, what it means is, for example, if you and I are communicating back and forth on an IM, using standard IM communication, then when we close out our conversation, that all disappears, like the Snapchat example I gave you. That information, even though inscribed in an electronic medium, would not be a record, because at the end of the conversation, when we closed the windows, we couldn't go back in and retrieve it in a form where we could see and understand it. So we really are talking about the electronic equivalent of paper documents that you can pull back up and look at and read, etc. But very, very deliberate non-use of non-definition of electronic medium. Yeah.
Sorry, this might be going into too much.
I'm happy to take the time.
It might be too much detail, though. That doesn't matter. But
We're all about detail.
So in Article 9, you're saying record because Article 9 recognizes signed in writing as actually physical signs in writing. It doesn't see the electronic.
Well, actually, Article 9 has a definition that picks up electronic signatures. Article 1 doesn't.
Okay.
Article 9 uses record for either as an omnibus term for either physical documents or electronic documents. And whereas the definition of sign in Article 1 is limited to the physical world, but actually would apply to the electronic world because of the external acts like the Electronic Transactions Act. Article 9 is self-contained and has a definition of that picks up electronic signatures.
Okay.
But here's I was going to get there in about 10 minutes, but let me do it now, okay? When Article 9 was being drafted, UITA was being drafted, but hadn't been finished, okay? And so the drafters of Article 9 wanted a term that would communicate to the world that sign meant more than just a physical signature. And so they did something that was really, I don't want to say dumb, actually their reasoning was good at the time, but it's now an anachronism. Rather than just having a new definition of sign for Article 9 that in paragraph 1 says, sign means what it traditionally has meant, and sign also means, and having a definition of electronic signature, they picked a brand new word, and the word they used was authenticate. And go to Article 9 right now and look at 9102. 9102 is the definitional, the long definitional section in Article 9. And it's alphabetic. I mean, there's so many definitions in here that it takes a while sometimes. But if you look at the word authenticate, which is number 7, everybody with me? 9102 sub 7. Authenticate means to sign. That's the Article 1 term. That's the manual signature, because Article 1 defines sign as a physical signature. So that picks up the Article 1 physical signature. Or, with present intent to adopt or accept a record, to attach to or logically associate with the record an electronic sound, symbol, or process. That's a definition of an electronic signature. So if I call up your cell phone and I say, and you're not in, okay, and I get your voice recorder, and I say, hey, this is Bill Henning, just wanted to let you know, da-da-da-da-da-da-da-da-da. Is that voice message a record?
Yes.
Yeah. Looking at the definition of record we just looked at, it is stored in an electronic or other medium and retrievable and perceivable form. You can retrieve it and listen to it. Is it signed? You betcha. I said, hi, this is Bill Henning. That identifies me, and I put my name in there for the purpose of adopting what was in the message and letting you know it was from me. So that is an authenticated record in Article 9 terminology, the equivalent of a signed writing in the physical world. I mean, it's a great topic. I'll spend a little more time. It's really not an Article 9 topic. But when you see in Article 9 that it says a security agreement must be authenticated in order to be effective, which you will see, then people start thinking, oh, do we have to get it notarized? No. If I send you an email that says, da-da-da-da-da, whatever, sign Bill at the end, I put my name Bill at the end. That's an electronic signature. Electronic signature under the definition of authenticate. Now I lost it. With present intent to adopt or accept a record. Well, I put my name on there with present intent to demonstrate to you that I've adopted it as my own. To attach to or logically associate with the record an electronic sound, symbol, or process. Typing my name? Okay. So when you see authenticate in Article 9, your brain needs to say sign. When we got around to revising Article, just for fun, you're not responsible. Go to Article 7. Okay. Article 7 was revised about 5 years after Article 9 was revised. And look in 7.102. And it does it the right way. Sign means, with present intent to authenticate or adopt a record, to execute or adopt a tangible symbol, or to attach to or logically associate with the record an electronic sound, symbol, or process. So we didn't use the clunky word authenticate. And it's just a matter of the history of the thing and how it came together and who was thinking what at what point in time. Again, when Article 9 was being drafted, they were looking for a word that would convey, we're putting more in here than just the traditional manual signature. So they selected authenticate. When we revised, I mentioned that there was a set of amendments to Article 9 in 2010. And when we revised Article 9 in 2010, we thought about changing authenticate to sign, because we could have done it, and it would have made sense. But instead of a discrete set of amendments that a legislator could look at and say, well, that's not very many, we would have had to amend dozens and dozens and dozens and dozens of provisions, and the package of legislation would have looked like that. And we were really scared that legislators would look at that and say, oh, that's a heck of a lot. We're not going to adopt that. You'd be amazed at the games you play to get legislators to adopt things that they don't look at because you really don't want them to look at it. You want to say this is part of the Uniform Commercial Code, your state needs it adopted. Boy. So, some more definitions real quickly. Actually, I want to go somewhere else. I want you to go to 9109, which I took you to the other day. And I indicated that it's always helpful to understand what circumstances, what transactions a particular statute applies to. You need a scope provision. What is the scope of the act? And 9109, again, leaving out the except as otherwise provided. 9109A1 is is the main thrust of this course. A transaction, regardless of its form, that creates a security interest in personal property by contract. But then it goes on, okay? And you're going to see the term agricultural lien. Article 9 applies to an agricultural lien. I want you to ignore it until I explain it later in the semester, okay? An agricultural lien is not an Article 9 security interest in agricultural stuff. It is a lien on agricultural products created by a rule of law other than Article 9. For example, if a mechanic fixes your car and you don't pay, then the mechanic, by operation of a statute, will have a lien on your car, but it's outside Article 9. Well, that's not an agricultural lien because it's a car. But if, for example, you take care of someone else's animals, then you'll have an equivalent lien on the animals. So it's a lien on property created outside of Article 9, but for reasons I'll explain later, it gets swept into Article 9 after creation, and some Article 9 rules apply to it. So we treat it for the most part like a security interest, even though it's not created by contract. But I will explain it later in the semester. The only reason I'm hitting it now is you can see the phrase, every time you see security interest, not every time, but almost every time you're going to see security interest or agricultural lien, and just read past it, okay? And then these other things, a sale of accounts, chattel paper, and hand, Article 9 primarily applies to the use of assets as collateral for a loan. But if, for example, I have a local bank that places real estate mortgages, and let's say they have 100 real estate mortgages, and each buyer of a home signs a promissory note. Those of you who've had the payment systems course can envision this. Promising to pay the purchase the amount loaned over 30 years. Just a debt instrument promising to pay, backed by a mortgage. And that note and mortgage are sold, not used as collateral, sold on the secondary mortgage market, then the sale actually is governed by Article 9. And there are reasons for this that you would not, if any of you guess and tell me the reason right now, I'll give you an A and you can leave. Okay? But I don't want you to worry about sales of these things. They involve sophisticated transactions at some point in the semester. We'll take half a class. I won't hold you responsible on the final exam. And I'll tell you why Article 9 does this. But Article 9 undergirds and provides rules that validate trillions of dollars in transactions through the sale of these payment rights. Okay? It is a phenomenally important provision, but it's not one we're going to look at. But the definition of secured party, as we'll see in a few minutes, will include a buyer of these kind of payment rights. And when you see that, you're going to say, what in the world is that? And what I'm telling you is ignore it. Okay? Till we get there, just ignore it. And then Article 9 applies to a consignment. And there's all kinds of consignments. There's a specific one that's defined for purposes of Article 9. And I'm going to tell you not to worry about it. Okay? So when you see all this, when you see the word consignment, when you see secured party in the context of someone buying payment rights, when you see agricultural lien, just ignore all of that. Focus on the security interest as an interest in personal property as security for, right? The definition in Article 1, the first sentence, a security for an obligation. So with that in mind, let's go back to 9102. And just look at the definition of secured party. This is 9102A73. Secured party means A, B, C, D, E, F. A person in whose favor a security interest is created or provided for under a security agreement, whether or not any obligation to be secured is outstanding. A person in whose favor a security interest is created or provided for under a security agreement. That's the main definition of secured party. Secured party also includes a person that holds an agricultural lien. Ignore it. A consignor. Ignore it. In other words, ignore the rest of this. Okay? With me? More or less? Article 9 is a framework for validating and supporting a host of transactions, not all of which we can learn at the outset. You've got to take baby steps. This is a curiosity, and I need to spend a minute explaining this. Go to the definition of debtor. And I can never find it in here. They're all the C's and then the D's. It's number 28. When you use the word debtor, if you were just using the English language, what would you think of? Somebody who was indebted? Somebody who owed a debt? Wrong. Debtor has nothing to do with indebtedness. I'll explain why the term is used in a minute. Debtor means a person having an interest, meaning a property interest, other than a security interest or other lien, in the collateral, whether or not the person is an obligor. Debtor means a person having a property interest in the collateral. The term debtor doesn't have anything to do with debt. It has to do with property rights. Okay? B and C, a seller of accounts and a consignee, you ignore those. Those are the flip side of the parts of the definition of secured party. Okay? Look at obligor. Number 59. Obligor means a person that, with respect to an obligation secured by a security interest in collateral, don't worry about ag lien, owes payment or other performance of the obligation, and then forget the rest of that. Obligor means somebody who owes the obligation that is secured by the collateral. Okay? Now, why is this done? Let me give you an example. And I started to do this the other night, but I won't carry it out and give you more details tonight. I want to borrow $25,000 from a bank. So we'll put my initials up here. And we'll put bank over here. But I put forth kids through college, so I don't own any assets. I'm lucky to have groceries. And the bank won't lend me the money without collateral. All right? You are my friend, and I say, you know, I really need this $25,000. Would you let me use your car? I understand your car's paid for. Would you let me use it as collateral for my loan? Okay? And you say, sure. Okay? The technical Article 9 term for you is an idiot. But we'll rock along and assume that you've said okay, all right? So, but you say to me, Professor Henning, you're borrowing $25,000. If the bank will take my car as collateral, that's great. It's only worth about $15,000 or $20,000. I'm not going to co-sign the promissory note. If you default, I'll let the bank go get my car and sell it. But if there's a deficiency, that's your problem, man. It's not mine. Okay? Still with me? So, I sign a debt instrument promising to pay. Okay? I sign the contract promising to pay, and you do not. You sign a security agreement giving the bank a security interest in your car. Well, okay. We're all part of the same transaction, right? It's all interrelated. But let's pick some labels. Here's the easy label. What's the label for bank? The Article 9 label.
The obligor?
I think it's the obligee.
Obligor, yeah.
It's not a defined term. Bank is the beneficiary of a security interest, right? Bank has the right to foreclose on your car if I, Henning, default. You can't default because you haven't undertaken a monetary obligation to the bank. What's the bank? No, the bank's not the debtor. Debtor is a person. The bank has a property interest, a security interest. But debtor means a person having an interest in the property other than a secured party, right? I'm sorry? They're the secured party. Sure. Yeah. It was too easy, right? You thought I was asking a hard question. So bank is secured party. Friend? Debtor. Am I a debtor? Debtor means a person having an interest, property interest in collateral, other than a secured party, whether or not that person also has an obligation. That's part of the definition, whether or not that person is also an obligor. So friend is a debtor, but not an obligor. What am I? I'm an obligor, but not a debtor. Okay? Now, take a parallel situation. Something about parallel. I go down to the bank, I borrow $25,000, I have collateral, I give the bank a security interest in my car. Okay? This is the way it happens 99+% of the time. I've only set this up this way so that I can play with the definitions. So I go down to the bank, and I sign a debt instrument promising to pay, and I sign a security agreement giving the bank a security interest in my car, and I've got a bank over here, and the bank is the secured party, and I am I a debtor? Yes. Am I an obligor? Yes. I'm wearing both hats, okay? I am both a debtor and an obligor. Now, why does this matter? It matters because sometimes sometimes we need to talk about the person wearing the hat of debtor, and sometimes we need to talk about the person wearing the hat of obligor. For example, let's play around over here. Let's say I do default to the bank, okay? And the bank comes and takes your car and sells it at a foreclosure sale. And lo and behold, it generates more money than the remaining debt. In other words, the bank can pay itself off totally and still has $5,000 in its pocket. You with me? I defaulted. The bank foreclosed on your car as it was entitled to do because you gave it permission by contract. It held its foreclosure sale, but I had paid the debt down and your car was worth more than you thought. The bank's sitting there holding $5,000 extra dollars. Who should the bank give that money to? The debtor, right? That's your money. That's your equity in the car, right? Why should I him get that? That money should go to you. So the statute should say that if there is an Article 9 disposition and a surplus is generated, the surplus goes to the debtor. Right? Now suppose that it doesn't bring enough to pay the debt, that there's $5,000 left owing. Who should owe that money? Who should the bank be able to pursue for a judgment for that $5,000? Only the obligor, right? So the statute should say, in the event of a surplus, the surplus goes to the debtor. In the event of a deficiency, the obligor owes the deficiency. So why do I have two different terms? So that I can be precise. And if a statute refers to a debtor, it's referring to the person with the property interest, the person who provided the collateral. If it's talking about the obligor, it means the person that is owes the obligation. If I have the simple transaction, which I have 99% of the time, and a statute says obligor, who's it referring to? Me. If it says debtor, who's it referring to? Me. Right? Same person. But I can speak in the statute with great precision by being able to separate these two concepts. So look for the language. Now, why use the term debtor for the person who provides the collateral? I mean, you'd think you'd have a better term than that. And the reason is that up until the revised Article 9 became effective in 2001, drafted in the late 90s, the term obligor was not used. Debtor was used for both. Sometimes it meant the person who provided the collateral, sometimes it meant the person who owed the obligation, sometimes it meant both, and sometimes it was ambiguous. So we decided in revised Article 9 not to allow ambiguity anymore, so that we would separate it into two concepts, so that we could speak with great precision in the statute. So obligor was easy. That conveys that you owe something. But what term should we use for the person who provides the collateral, the person with a property interest? And we tried various things, but in the end, the entire commercial world had known that person as a debtor for 40 years. And he just stayed with debtor. But oddly enough, you have learned tonight that a donee of a gift is a purchaser, and a person with a property interest who doesn't owe any money is a debtor. Okay? Now, when I've said you need to think carefully and look at the definitions when you read these statutes, you begin to see why. Okay. Again, I'll take questions.
My only question is, what does it say between WH to the bank? It says, is that debting or debt?
Oh, D&O?
Okay,
Oh, between us it says security agreement in the car. Oh, I signed the debt instrument.
Okay,
I signed
sorry.
two documents. I like it. We often combine them in one.
Okay.
And we have one document that says I'll pay of such amount of money, and you can have a security interest. But I like for you all to think in terms of the debt part and the security interest part separately. So I want you to think in terms of signing something, and of course I can bring myself to say record, but I cannot bring myself to say authenticate. So I'm just going to say sign. So I want you to think of the debt and the collateral in different thought processes. So I have two different documents. Maybe a promissory note representing the debt and a security agreement granting, where it says I hereby grant the bank a security interest in my car as collateral for the debt represented by the promissory note. Okay.
If the friend that is the debtor also wants some responsibility of the debt?
No, because I set it up. I didn't set it up that way.
No, but if it would have been that way, do we still call him the debtor?
Well,
or will we
I
call him
I
the
could have my friend provide the collateral, okay, and co-sign the note.
So in that case, we call him the surety, or we call him
No,
the
no, no, no,
debtor still?
No, okay. In that case, friend is providing the collateral, is still a debtor, has taken on an obligation, so is an obligor, and also fits in the definition of in Article 9 called secondary obligor, which means a surety, and it's a nesting definition. Obligor means anybody who has a monetary obligation. Secondary obligor is a person who has a monetary obligation, but it is secondary, like a surety, or for those of you who took payment systems, an accommodation party. For the rest of you, don't worry about that term. Okay, it'll keep you up at night. So if a statute says obligor, it means both primary and secondary obligors. If a statute says secondary obligor, it is referring only to the surety. Okay, so you made me give you another term, which I wasn't going to do until we did the disposition stuff, the foreclosure stuff. There are some rules that protect secondary obligors in the event of foreclosure. But until we get to foreclosure, secondary obligor is not a term you need. Okay. For today's purposes, if I had this person also sign the debt instrument, I would call this person both a debtor and an obligor, and I would, up here I would be an obligor but not a debtor. Since I'm almost out of time, no, never mind, I'm not going to do this. It's too complicated. I can do it later. So I think those are the main definitions we need to get. Let's look at a couple of others. Definition 74, security agreement. Our version of Article 9 is a security interest created by contract. The contract we call a security agreement. Security agreement means an agreement that creates or provides for a security interest. Creates or provides for. I own my car. I sign a security agreement granting the bank a security interest in my car. The security agreement has created a security interest. I'm borrowing money from a bank to buy something. I sign a security agreement describing the thing I'm going to buy. But I don't own it yet. The bank gives me the money and I go out and buy it, and now I own it. And I've given the bank a security interest. The security interest didn't create, the security agreement didn't create the security interest because I didn't own the collateral then, but it provided for the creation of a security interest in the future when I acquired the collateral. So don't read too much into the creates or provides for. Creates means it creates it now, provides for means the security interest will arise when certain conditions are met in the future. I think those are the terms. You did authenticate. You'll notice that record, number 70, record is slightly different than the Article 1 definition. Again, it means information inscribed on a tangible medium or stored in an electronic or other medium and retrievable in perceivable form. That's the same as Article 1. But Article 9 uses the term record in other ways. It uses, you do something for record, or you talk about something that is of record, or someone is the record owner. So what we had to say is that record doesn't mean information on a physical or electronic document if you're talking about the person who is the record owner of property. So we use record in different ways, and we're just trying to be a little more precise with that definition. But the core definition of record is the same. Article 9 uses writing in one place. Does it need a definition of writing? Yes, no, maybe, I don't know. What's he talking about? Those are your options. Doesn't need a definition of writing because it's in Article 1, right? So, I'm not shocked that I didn't get to the voidable title material tonight. I want us to, this is going to rapidly get layer after layer of complexity. I want to lay a floor underneath us, okay? But I will cover all of the material in the material on voidable title in handout 2. And you are at risk that I could get into handout 3 in the next class period. If I do, then it probably won't be very far into it, but I could get into, let's say, the first few problems in handout 3, the first 2 or 3 problems in handout 3. Okay? And next class is not Monday because we're off. Next class is next Wednesday, right? If you have questions and want to stick around, that's fine. And if you didn't sign the seating chart and want to do that, that would be great too. I'll stick around for a minute. We're done.
If Alabama won, does the average
Oh.
bump up a couple points this year?
If you're just a football fan, you must have enjoyed that game, and I did too. But the good thing is that the long 2-year drought is over at Alabama.
No, it's not. I mean, I would love to see it. I had contact that game.
Yeah, that was a great game, and both teams deserved to win that game.
Yeah. Poor Nick Saban, he's running out of fingers.
Yeah. And I didn't want to call on anybody today because I wanted to announce my policy that you can opt out, but I am going to call on a bunch of folks next Wednesday.